Hello everybody, good morning and welcome to our LBTT Residential Update webinar. We're delighted that so many of you have been able to join us. My name's Isabel D'Inverno, I'm Head of Corporate Tax at Brodies, and my colleague Bob Langridge, who's an associate in the Corporate Tax team, will also be participating in the seminar. We want to speak to you about a number of things this morning, and there are slides which we will send out to you and which hopefully you can see on the screen in front of you, and there is a question box as well for asking questions. So we're going to cover some of the hot topics. One of them is the proposed new SDLT levy for foreign purchasers. The next one is quite a question of the moment, which is the distinction between residential and non-residential land, and particularly how this affects mixed purchases. Then there is multiple dwellings relief, which is a bit of a Cinderella relief because it's not claimed as often as it should be. And we'll also say something about first-time buyers relief. So starting off with the proposed new SDLT levy, this was announced by Theresa May at the Tory party conference, where she said that there would be an additional SDLT levy of up to 3% on purchases of residential property by non-residents. This was then tweaked slightly in the budget speech on the 29th of October, and it's now become a 1% levy. It's going to be subject to consultation, which will start in the new year, so we don't really have any details, but it's probably not going to take effect until 1st April 2019 at the earliest. And a lot will depend on the consultation, and there will be some quite difficult practical issues to deal with. Why do we care about the SDLT levy? Well, the point is that if it's introduced for SDLT, it may also be introduced for LBTT. When will we find out if that's going to happen? Well, the Scottish budget is on the 12th of December this year, and that's the time when we might expect the Scottish Government to make an announcement about the LBTT levy if they're going to introduce one. And of course, the last time there was a 3% SDLT levy, it was replicated in LBTT. So there is a possibility that this might happen, and also that it might not just mimic the SDLT proposals, but might be a bit different here. So probably the message is to warn clients of the possibility of this coming in, and of the possibility of it being further sort of elaborated on in the Scottish budget. And in the Scottish budget, of course, there could also be changes to the rates of LBTT. We have no reason to think that there might be, but there could be.
The next issue, which is, as Isabel said, really a hot topic at the moment, is the distinction between residential and non-residential property. Why does this matter? Simply put, the residential rates are significantly higher under SDLT, LBTT and the Welsh LTT than the non-residential rates, and we have a mixed property regime. That means if you're buying something that is residential in part and non-residential in part, then the entire purchase is taxed at the non-residential rates. Similarly, if you have two distinct transactions which are linked, a residential one and a non-residential one, then both transactions wind up treated as non-residential. The only sort of exception to that rule are when you look at claiming multiple dwellings relief, which we'll talk about, but also when the additional dwelling supplement of 3% applies, although that only applies to dwellings and not the entirety of the property in any transaction. So what is residential property? Residential property defined in the LBTT Act as a building used or suitable for use as a dwelling, or in the process of being constructed or adapted for such use. Used or suitable for use is important to note because you could take account of past use when you're considering whether a building is in fact a dwelling, for example, if it's currently used as a bed and breakfast. In the process of being constructed or adapted, this likewise means that you don't have to have a finished building, provided it has reached a stage in construction where you are actually building the dwelling itself. then that will qualify for a dwelling. So a purchase of a bare plot of land with planning permission will likely be treated as non-residential. However, the purchase of a plot where the foundations have been dug and people are perhaps starting to run services and utilities is going to fall on the residential side of that. So the starting point of that definition is having the right kind of building, and caught in that definition is any land that is or forms part of the garden or grounds of that dwelling or exists for the benefit of that dwelling. And that also includes any other buildings sitting on that land. So that's quite a wide definition of residential property. Non-residential property starts off with a negative definition, simply that if something's not residential, then it's non-residential. And there are also a number of carve-outs, things that would otherwise be within the residential definition, which are carved out and treated as non-residential instead. These are mostly aimed at things that have a sort of quasi-residential use. So children's homes, care or assisted living facilities, university halls of residence, hotels and inns and prisons are all excluded, even though they are places where people do live.
Although with halls of residence, of course, it's only the old style that are treated, halls of residence that are treated as non-residential, because new style university so-called halls, but they're actually flats generally now, aren't they? Purpose-built student accommodation, and they would count as residential. But anyway, the other thing is the fact that if you buy 6 or more residential properties at the same time, that's also treated as non-residential, the 6+ rule, or the 6-pack rule.
Yes. As we'll see when we talk a bit more about mixed purchases and sort of difficult cases, there's a bit of uncertainty about where the boundary between residential and non-residential is, and there are differing views between practitioners and tax authorities. With respect to the 6+ rule, as Isabel said, it's a single transaction that triggers it. So it has to be 6 or more properties in a single transaction. And again, it's not entirely clear from the statute books what constitutes a single transaction. However, for LBTT purposes, because LBTT is a distinct tax from SDLT or LTT, if you're going to rely on the 6+ rule, it's absolutely vital that all 6 of the properties are in Scotland.
Yes, that can be a bit of a shock if you're buying 5 in Scotland and 1 in Wales. It doesn't work. And it has to be, as Bob has said, a single transaction. You can't get the benefit of the 6+ relief if you're buying things in linked transactions. So that's a really important distinction. For the 6+ rule, it's got to be a single transaction. So if you buy 6 or more properties as part of a single transaction, they will be treated as non-residential, and you'll pay the non-residential rate. It's not 6 or more linked transactions. It's got to be part of a single transaction. What is a single transaction will depend on the facts. For example, you don't actually have to have a single contract. You could have more than one contract. You could have 6 individual contracts, so long as it's all joined together sufficiently well to amount to a single bargain, or to be able to demonstrate that it's a single bargain. Then that will count as 6 or more transactions, 6 or more purchases as part of a single transaction, and so you get the 6+ relief. The other thing to bear in mind is that it's not a portfolio test. So if you've already got 1 property and you buy 5, you don't get the 6+ relief. You've got to be buying 6 or more as part of a single transaction. You can have split completion dates as well. So you could have a contract for 6 and you complete it on different days. That would be okay, but not if you start off with 1 that you bought ages ago and now buy 5. That doesn't work. And as we've said, all 6 need to be in Scotland. So the difficult part of all of this at the moment is really the question of mixed purchases. A purchase which includes non-residential property is non-residential, but where the boundaries are is causing quite a lot of difficulty. So, what are the main areas that Revenue Scotland are looking at just now? The examples which are in the manual, the LBTT manual, are not really very helpful. The standard example is a shop with a flat above, but obviously mixed purchases go a lot further than that. So you could have a country house with shootings, fishings, grazing and so on, a farmhouse together with farmed land. All of these are mixed purchases. Part of the purchase is residential, the house part of it, but the other part is not residential, it's being used for some other purpose, and therefore the whole thing is a mixed purchase. However, Revenue Scotland and HMRC as well, to some extent, are looking at all of this a lot more closely, and that's because the rate is so much lower if you can get the non-residential rate. So they're looking at situations like a house in the country where there's a field which is let out under a grazing lease, and they're asking questions about that. They're raising questions about situations like a farmhouse where there is farmland which is not currently being farmed. Does that still count as being a mixed purchase? Or a house with woodlands in the grounds, are they actually commercial woodlands, or are the woodlands just part of the garden of the house effectively, where they're really just acting as a windbreak for the house? What can you do about all of this? The best thing is to try and get the best possible contemporaneous evidence. On the grazing leases, if you've actually got a signed grazing lease or license, then you're in a better position than if it's just a question of a farmer who's allowed to graze animals on the field in exchange for mending the fences. If the grazing lease has expired, it's probably better to get another one in place, or to ask the sellers to get another one in place, because it's quite clear that Revenue Scotland are looking at these. And from their point of view, you can see why it's worth questioning it, because one field being let for a fairly low rent can actually massively decrease the LBTT that's payable on the entire purchase. So in some cases, for example, they find that there isn't a grazing lease and it's just a sort of informal arrangement, and so they won't accept that it's non-residential. Similarly with woodlands, make sure you've got as much information as you can to support the fact that it's actually being operated on a commercial basis, so Forestry Commission, paperwork and all the rest of it. If there's a shop with a flat above, make sure you know when the shop was last open, if it isn't open at the moment. So this is all trying to bolster your case. But we're also aware of the fact that Revenue Scotland in some cases may be taking perhaps quite an aggressive approach. So it's worth just thinking carefully before you respond to a letter to make sure that you know what you're actually, what question you're really answering before you just helpfully send in a lot of information which might shoot you in the foot.
It's also worth perhaps noting that a lot of the cases we have seen or heard of where Revenue Scotland have challenged non-residential treatment, their arguments have boiled down to the idea that there isn't a commercial or profitable use of the property, even though the legislation itself does not stipulate commerciality as one of the tests. So if you are preparing evidence, or you are looking at responding to a Revenue Scotland letter, it's worth bearing that in mind as well. Even though it's not technically correct, anything that can evidence a commercial use or commerciality or a profit motive is going to be helpful in establishing that case. Revenue
Scotland are comparing notes to some extent with HMRC and also with the Welsh Revenue Authority, the new tax authority which is administering the land transaction tax in Wales. HMRC do look at the use of the land at the effective date, which again isn't entirely in the legislation, but it is how things have grown up and developed. But they look at a basket of different indicators, so how is property treated for council tax purposes, what is, as Bob said, the current use of the land, what is even what the purchaser is going to use the land for, which isn't really part of the test at all. The LTT guidance, the Welsh guidance, is perhaps more extensive than HMRC's guidance or Revenue Scotland, and I think both will develop. But it's certainly a difficult area where it's worth not just giving up at the first hurdle, but trying to argue your case.
Okay, the next thing we'd like to talk about is multiple dwellings relief, or MDR, as people normally call it. Multiple dwellings relief is one of those reliefs which probably is available a lot more than it is claimed. One of the reasons it's not claimed often, we surmise, is simply people aren't aware of it. Another reason is that it is something that is very property specific, and it's also not 100% relief from the tax. Rather, it reduces the amount of tax you pay rather than cancels it out altogether. The relief itself is available whenever two or more dwellings are acquired in a single transaction or linked transactions. This can include, buying two houses together, several flats in a block, modern purpose-built student accommodation, which is basically a block of flats with additional common areas. If you're buying a farmhouse or an estate, and there are farm or estate cottages on the premises, those will be multiple dwellings, and also a main house with a granny flat or an annex to it could easily fall within the qualifying conditions for multiple dwellings relief. The right you acquire has to be ownership. Unlike SDLT, with LBTT multiple dwellings relief, a lease, even if it's a long lease, interest in land will not qualify. And the way that LBTT MDR is worked out is by doing two calculations and then choosing whichever one gives you the highest answer. So the first calculation, you work out the average consideration for each dwelling. You multiply that by the residential rates, and then you multiply the answer by the number of dwellings. The second calculation, you work out the tax without MDR, and you simply divide that by 4 or multiply it by 25%, and that's called the minimum prescribed amount. An important point that's often overlooked around that second calculation, the minimum prescribed amount, is that if your purchase is non-residential, either because it's a mixed property that you're buying or you are buying 6 or more dwellings, you are applying the non-residential rates, and then you're multiplying them by 25%. There is no kind of inherent assumption in MDR that you have to treat what you're buying as residential, unlike is the case with SDLT.
So you can get quite a good result in LBTT compared to SDLT. The figures can be lower.
So this next slide just illustrates the formula that are used. So your first formula, dt times nt plus rt. This is tax due in relation to a dwelling on the average price times the number of dwellings, plus any tax on anything that's not a dwelling. We'll come to that in a moment. And then the second formula, dt times nt, if it's less than minimum prescribed amount, plus tax on anything that's not a dwelling, then you use the minimum prescribed amount instead. If you do have a mixed purchase, then you need to differentiate between what is dwellings and what is not, because MDR will only apply to the dwellings in the purchase. So, for example, an estate which includes commercial woodlands or shooting policies, those woodlands or those policies will be non-residential property and will not form part of the dwellings. So first step is that the purchase price needs to be apportioned between the dwellings and the parts that aren't dwellings, Now, normally you would be doing this anyway on this kind of purchase because you need to account for the additional dwelling supplement. And as the tests for dwellings for the ADS and MDR are the same, you can use the same apportionment. To work out the average dwellings basis, you simply take the amount apportioned to the dwellings and divide that by the number of dwellings. That's quite straightforward. To work out the amount for the remaining property, i.e. the non-residential portion, what you need to do is work out the total tax without the relief on everything, and then prorate that between the amount of your price that's apportioned to the residential and the amount that's apportioned to the non-residential. And the amount that's apportioned to the non-residential is simply the amount of tax that won't benefit from MDR.
So it sounds quite complicated, but it is worth going through it and claiming it because you save a lot of tax. It's also worth, if you are claiming it, sending Revenue Scotland a computation, because generally they ask you, when they receive a claim, they ask you to send your computation to them, so you may as well send it in the first place, really. But it is well worth going through, crunching the numbers to see whether the MDR will benefit you. It doesn't always. It depends on the price of the individual houses, and it's probably not wise to kind of guess at it. You need to go through the calculations. So here's another example that Bob's going to just run through.
So this is quite a simple example, a purchase of 6 flats and 2 shops. So imagine this is just a block for 1.4 million. There's no VAT on the price, and the apportionment is simply £1 million to the flats and £400,000 to the shops. First thing to note is that there's no ADS on this purchase because we've got 6 flats and there is a relief for 6 or more dwellings from the ADS. So we're squarely within the non-residential rates, and that leads to LBTT of £53,240. Prorating that using the 1 million and the 400,000 gives £38,000 attributable to the flats and 15,211 attributable to the shops. The average price of the flats then is 166,000. That's 1 million over 6, and the LBTT on each flat would be £433 on this method of calculation. So the LBTT on the average basis for all the flats is 2,598, which is 433 multiplied by 6. By contrast, we then have to do the minimum prescribed amount calculation, which unfortunately, due to a technical issue, isn't shown on this slide. But the way we do that is simply take the 38,029 apportioned to the flats, multiply it by 25%, which gives us £9,507. That's higher than the 2,598. So the amount attributable to the flats with MDR is 9,507. The amount attributable to the shops stays static at 15,211. So the total amount of tax payable is £24,718, which is less than half of the amount payable without the relief. So that should illustrate that it is, even if it can be a bit tricky to work out, a very valuable relief indeed.
So finally, first-time buyers relief. This was introduced probably in response to the SDLT relief, but it's not as generous. It raises the zero tax threshold for first-time buyers from 145,000 to 175,000, but the maximum relief you can get is only £600. For some people, that's quite annoying if they're in an area where people one side of the border can get the SDLT relief and the other side of the border it's only this £600. The slightly tricky thing about it is that it's a lot more complicated than you might think. There are in fact quite a few conditions that need to be met before you can be happy that first-time buyers relief will apply. Revenue Scotland have produced quite a lot of guidance, but the time that you might spend looking through all of that guidance and making sure that your client fits into it and that there's nothing that will trip you up could be quite extensive. And sometimes we have taken the approach of saying to the client, you may be able to claim first-time buyer's relief. However, it'll probably be more expensive if we look into it than the amount that you could save. So would you be happy if we just don't check that out? There are a lot of wrinkles about whether the individual has inherited a share in a property and all sorts of other ways in which they might have an interest in a property and things like that. So it's a bit of a sledgehammer to crack a nut and has dangers, really. That's the message. But if your clients want to get the benefit of it, then please do trawl through all the conditions in the Revenue Scotland guidance at the link which we've included on the slide.
Yes, and one thing just to note about the conditions, I think, is that a lot of them are very similar, both in terms of the drafting and their effect, to the conditions that can apply to ADS, which is why we've not tried to go through them in detail on these slides, since ADS itself was an entire webinar giving a high-level view. But it's things like, as Isabel said, inheritances, elements of property that you already own. Perhaps you are connected to someone who already owns residential property, and also various rules around trusts and identifying rights and trusts which can deem you to own property even though your client may not have an actual residential property in their own name.
Yeah, so it's a terrifically complicated set of provisions relating to this relief, and it's the kind of relief that you wonder whether it was a good idea to introduce it really in the first place. Okay, we hope that you've found the webinar useful. If you have any questions that you would like to raise, please feel free to email us. Our email addresses are on the slides, and we'd be more than happy to give you an answer. But in the meantime, thanks very much for joining. We'll be sending around a recording of the webinar as well as the slides themselves. And please also let us know if there are other topics on which you would like to watch a webinar. So do please let us know. Thanks a lot.
Thank you.